Our show it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property that'll be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody, and welcome to the show. Today, we're talking about the impact of Wisconsin's recent wholesale disclosure law. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like the channel and subscribe. You can find us on X, Facebook, and you can find us on YouTube. At all of those places, you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, I want you to go to Apple or Spotify or one of the other podcast platforms and download an audio version of the podcast. Doesn't cost anything. Leave us a review, like it. We'd really appreciate it. Helps us out a ton. With that, we're going to go to Sean, who has our legal update.
Andy. So it appears we have a theme happening. So last week, our show was about wholesale regulations in South Carolina. This week, it's about certain wholesale laws and regulations in Wisconsin. And then my legal update today is talking about Pennsylvania's recent wholesale regulations that were just passed, but they do not go into effect until January 1, 2025. So there's still a little bit of time for wholesalers to, do some transactions through the end of the year before this new law comes into effect, and really is going to have a major impact on the ability to engage in wholesaling. I'm going to go into just kind of a brief overview. I imagine or suspect that we're going to have a show on this here in November or December with an attorney that's from or licensed in Pennsylvania who can go through this in greater detail. But basically, as I indicated, it goes into effect January 1 of 2025. And one of the key provisions, it amends the definition of a real estate broker to include and encompass the act of wholesaling. So if you're going to engage in wholesaling in Pennsylvania, you have to have a real estate license. So that's one of the major changes. And then the second change is the disclosures that need to be made in the contract. And today we're going to be talking about disclosures that have to be made in Wisconsin, which frankly aren't that big of a deal. As long as they're made, you're good to go. Pennsylvania, you have these disclosures, but they really impact the nature of the transaction. So starting first with just your basic disclosure of, hey, I'm a wholesaler. You have to put that in your contract. I intend to assign the property. I'm not going to end up being probably the end buyer. You have to have that type of statutory language in the contract. The statute that they passed has the exact, magic language you have to put in there. But basically, you're disclosing the fact that you're a wholesaler and that means that you intend to assign the contract prior to closing. Then you have to include a statement that the seller has the right to obtain an appraisal for the property and to obtain legal advice. So you have to notify the seller, hey, look, you can go and obtain an appraisal of the property and you can seek legal advice. Well, you think, okay, well, why? So you give that disclosure and the appraisal comes back lower than what the purchase price is. So what? What's the remedy? What can the seller do? Well, the seller has the ability to cancel the contract or to rescind the contract. And that's another disclosure that has to be made. You have to disclose to the seller that they can cancel the contract up to 30 days from the contract's effective date, or the date of closing, whichever is earlier. So if you have a contract that has an extended escrow period or has a 30-day escrow or 40-day escrow, the seller has up to 30 days to cancel that contract. So if they go and they obtain an appraisal of the property, the appraisal comes back much higher than the purchase price, and they realize, oh, I'm losing a lot of money here, they have a right to go and cancel the contract. And it's 30 days. That's a long period. It's not like some states and certain contracts you have to have, for example, Colorado, on certain contracts, you have to have a 3-day right of rescission. Nope. This is a 30-day right of rescission or the date of closing when it actually closes, whichever is earlier. And then finally, you have to disclose in the contract that if the seller cancels the contract, that the buyer will repay the seller whatever money the seller may have paid, which is unusual because normally on a wholesale contract, I'm not aware of the seller regularly coming out of pocket. But to the extent the seller has paid anything or committed to pay anything, they're released from that obligation. And if anything's been paid, those funds are going to be refunded to the seller. So it's pretty extensive, and it's going to impact wholesaling in Pennsylvania. Frankly, it may even make it so that you can't wholesale. So while wholesaling in Pennsylvania will be legal still as of January 1, 2025, you have to have a license. And then the seller is going to have a number of remedies if they end up having seller's remorse or cold feet regarding the transactions, and they will be able to cancel for up to 30 days.
All right. Thank you, Sean, for the legal update. With that, a couple announcements. It's Tuesday. That means every Tuesday at 2:00 p.m. Arizona time, we have the Creative Finance Collective. What is the Creative Finance Collective? That is a live broadcast, a live show of professionals, mainly attorneys in the space, to discuss creative finance, to discuss the laws as it applies to each of those lawyers with respect to their states, to talk about what we're seeing go right, the things that we're seeing go wrong in a creative finance transactions. And we discuss how to make our forms better, how to make our representation of clients better. But what we also do is, for the entire hour, is answer questions from you, the listener. So if you have questions about creative finance, about the subto space, about buying real estate subject to the existing loans, there's not a lot of players in that space. And the purpose of the Creative Finance Collective is to bring them together from different states. So if you attend and participate, you're going to hear from lawyers from Texas, Arizona, Florida, Georgia, Alabama, Ohio. We've had them from all over the place. So this is an opportunity for you to engage with professionals that see it done right and see it done wrong, and can discuss the benefits and the risks associated with that type of transaction. So the Creative Finance Collective, 2 p.m. every Tuesday. Make sure to join us. We'll be on for as long as we're getting questions. Also, if you have questions for Sean or I or our guest today regarding our topic, we're going to take any questions that we get in the final 15 minutes of the episode. So make sure you post those in the chat, and we'll get to those. You don't need to wait to the end. We're monitoring the chat and collecting the questions as we get them. So make sure to post those as we go. All right, so let's get into our topic today. We're talking about, as Sean mentioned, we've been talking about, if you've been following us, wholesaling laws, wholesaling regulations as they've been passing. We've been talking for some time that if we saw regulation in the real estate space, we'd see it in wholesaling, and that's exactly where we're seeing it. Last week, we talked about South Carolina's law. John was talking about Pennsylvania's. Today, we're going to talk about Wisconsin's. And with us to discuss the recent wholesale disclosure law passed in Wisconsin is Amy Farrow. Amy, thanks so much for joining us.
Oh, thank you guys for having me. I appreciate it.
Yeah, so Amy, I know you're an attorney over there or up there from where we are in Arizona, in Wisconsin, where the weather is no doubt much better than it is here right now. Tell us about your law practice, the law firm, and how you got into doing what you do.
Sure. I've been a lawyer for, I can't believe, 27 years now, and 22 of those I've been practicing. 5 I spent working for the government. And my practice is entirely real estate investors. And they get into, as you both know, a wide variety of trouble. But so I deal with contracts. I deal with when they get sued. I'm generally the one that's helping them. So long story short, if you're a real estate investor, you're in Wisconsin. I'm also licensed in Texas. And I do a wide variety of things for a wide variety of clients. My specialty, honestly, is litigation. So when these statutes come out, I'm generally the one that is either most likely defending the real estate investor. I have a long time practice of defending flippers in basement problems and all sorts of other contractual problems that they might have. And so it's been a long time. It's been a good road. And I like to say that I've seen just about everything that you can see real estate investors do. And having been a real estate investor for over 20 years now as well, I've flipped hundreds of houses, wholesaled a lot of deals. I've done creative financing, both seller and land contracts. And so there's pretty much nothing that I haven't seen in the real estate investment space. I've also developed masterminds with other investors. We're working on developing a mastermind right now. And so we're hoping to really bring newer investors together and kind of handle these questions that are coming up now in different states. Is it illegal here? Is it illegal there? What can I do to get around it? Those are very legitimate questions that we're seeing a lot. So I'm looking forward to starting to address them and working through the process of when it starts to litigate, because I don't think it's if, I think it's when we start to litigate on these issues.
No doubt, no doubt. Well, Amy, Sean and I are a couple old boring guys. And when we heard that you spent some time with the FBI, we thought that was pretty cool. Tell us about that.
I did. So I graduated from law school, and you guys are probably sympathetic to this, but practicing law can be very boring. And especially when you're a new lawyer and you really don't know what you're doing and you're trying to learn a new skill that law school doesn't really prepare you for, and you're working for a big firm, it's a bit like watching paint dry on the wall sometimes. And I had a friend who I went to law school with who only went to law school to join the FBI. And so I went down to visit him. My husband and I went to go visit him and his wife in Phoenix. Actually, he was in the Tucson office of the FBI. And so we went in the winter when it really was not fun to be in Wisconsin, and it was great to be in Arizona. And I started to get recruited, and I had no idea I was being recruited by the FBI. I just thought they wanted to talk to me, and, it was fun. And one day they came knocking on my door and, wanted to interview me, and it kind of took off from there. And I kind of accidentally ended up as a special agent with the FBI and went to Quantico and learned to shoot and learned all sorts of different skills. And then I ended up going to Oklahoma City as my office. And I spent almost 5 years in Oklahoma City. And then, as you might expect, I had a baby, and it was not so much fun being out at, all hours of the day chasing people anymore when you have a little baby. And that was right when September 11th happened as well.
Oh, wow.
So my job changed dramatically on two fronts. I was a new mom, and the FBI's job sort of changed dramatically that day. So left, came back to Wisconsin and started practicing law again. Lasted at a firm through another baby, and then realized I need to go out on my own. And so I went out on my own with two little kids, and then crazily I had a third. And so I really was solo practice for a very long time. And then I joined a firm earlier this year so that I could really get some backup, because for the most part, my practice got pretty busy with real estate investors and a couple different kinds of law. I do a lot of business law, and I take some very simple sort of traffic type stuff just to stay in court and keep things fresh. And I think I have like legal ADD. Like if it's not different every day, I get a little bored, and then I go look for something to do, and then different things kind of come up. And so I have a very eclectic practice, and I really like it that way. I like it that way a lot.
Now, as an attorney, you've represented real estate investors. Are you a real estate investor yourself?
I am. I actually got licensed in 2004. So I have a really weird real estate investment background, as you might expect. The rest of my career has been weird, so that should be weird too. I actually started flipping houses. That was the first thing I did. I had a friend who was flipping houses, and I joined him, and that's how I learned everything about houses. He was a home inspector and a plumber, and I learned everything on the ground by asking electricians questions like, why are you doing that? Why are we doing this? Why do you set a toilet that way? What's a soffit and a fascia? I don't know what that is. And so I was flipping a whole bunch of houses, and I realized I am paying a load of money to these real estate brokers and agents. And I'm an attorney. I only have to take a test, and then I'm a broker and I can do whatever I want. This sounds great. I should do that. And so I did. And back then in the Wild West, when most of the people that are listening to this probably weren't even born yet, I put signs in the yard, and I mostly sold my own properties, and there wasn't as much regulation as there is now. I didn't even know until a couple of years ago that if you were a brand new real estate agent, you had to go for a period of time and you had to learn under a broker before you could be one. So I didn't even know that existed. I was just off doing kind of my own thing. And so I don't generally act as a realtor now for anyone else. I don't list people's properties, and I have a really great network of agents that I work with when a property needs to be listed, and they're the professionals. So I let the professionals do what the professionals should do, and I try not to ADD myself right into something that I shouldn't be doing. So.
Well, so today we're here to talk about specifically the disclosure laws and the disclosure law as it applies, or the one that was passed in Wisconsin. We're going to dive into a lot of the details on this, but kind of from 30,000 feet, why don't you break down for our listeners what the law is, where it can be found, and when it went into effect?
Sure. So the new wholesaler law, as we'll call it, is just basically a disclosure law. It came out sort of silently in March of this year. And I say silently because it worked its way through the legislature actually fairly quickly. It was proposed in 2023, and it was issued and made it through the House and the Senate and became law in 2024, in March of 2024. And where did it come from? It sort of came from what happened in Illinois, where they really wanted to regulate wholesaling a little bit more than it was right now. And because our political nature here is a little bit complicated, it only came out as a disclosure. So the statute is 710.13 of the Wisconsin statutes. Not that anybody, other than lawyers really care, but if you needed to find it, you can Google it. And what it basically says is it defines what a wholesaler is. And the definition in Wisconsin is someone who intends to assign a purchase agreement to someone else. And a purchase agreement is any document for the purchase, sale, optioning, renting, like that's the definition in whole. And then when we go into that statute, it was sort of like, they sort of like picked and chose a little bit about how they were going to apply that. But what I tell my clients is, look, if you intend to wholesale it and you're writing it in a contract, you need to disclose. Don't worry about what the statute says, because I think it's going to be very wholesale applied to any kind of purchase and sale agreement, contract, document, napkin, whatever they put their agreements on. So whatever agreement you have with the seller, if your intention is to wholesale it to someone else, you need to disclose to them. And what does that disclosure say? It says, I am a real estate wholesaler. And so you have to put that language on there. And then what I generally tell people is take it right out of the statute and put it on your contract. And at minimum, just say, I'm a real estate wholesaler as described with statute 710.13. You put that on there, you're pretty much covered for that kind of disclosure. It's not a regulation. It doesn't say thou shall not wholesale in the state of Wisconsin. It doesn't say that. It says you have to disclose that you're a wholesaler. And then people always ask me, well, it's a duplex. Do I have to disclose? Yes. residential property, 1 to 4 units is when you really should be disclosing.
So a few follow-up questions on that.
Sure.
I have a number of real estate investors who operate under multiple entities. And one strategy that a number of my clients use is they have what I would call their contract entity. So this is the entity they enter into all their purchase contracts with.
Sure.
But that's not the entity they close with. They close with an affiliated entity. And
Or entities.
Entities, yeah. And prior to closing, we just do a simple, little assignment, moving it over to that, entity. Does this law prohibit that? Meaning, not prohibit, because there is no prohibition.
Right.
But does that law then mean that if I'm going to there's not a third party buyer, it's just my related entities. So do I have to then disclose on the purchase contract that I intend to assign it, or I'm a wholesaler, even though it's just going to an affiliated entity?
Well, technically it says if you're doing a third party that you have to then give your seller notice, and then you also have to give your buyer notice. So this isn't just a one side, you have to give the seller notification. If you are then intending to wholesale it to a third party, you have to give that third party the same notice. I'm a wholesaler, I'm going to wholesale this to you. And it seems kind of redundant that you have to do that, but you have to put it in your contracts on both sides, because the penalties are really severe. They're very severe. The first penalty is if you don't disclose to the seller, they have the option to rescind your contract up until the day of closing. So you could get day before closing, and if you didn't disclose, they can back out. But the worst part of it is they get to keep your earnest money. So if you paid any earnest money in your contract, they get it when they rescind. So I tell my clients, over disclose. Even if you plan to put it into your own entity, I think that's technically a third party, and I would just disclose. I would just disclose, because if you are not being open and honest with the seller, and all of a sudden you feel like this is a heart attack for you to have to disclose this on your offer, I think you probably should reevaluate how you're doing business, because you're not being honest with the seller to begin with in this disclosure. It really shouldn't be news to the seller that you might assign this or that you intend to assign it. They should be telling the seller that. So I think I would put it in there because the penalties are too high not to.
So when we were offline, we were talking briefly about the history of this regulation or requirement, and you indicated, this was kind of just stuck in a much broader bill. What were the other provisions of the bill that was passed that included this disclosure regulation?
Right. So the funny thing is, this disclosure was really at the very bottom of the whole statute that was amended. And the bigger part of this statute is part 452, which regulates realtors, basically. And I'm going to say realtor, even though the proper term is licensee, because, we're talking about agents and brokers and the regulation of them. And so when people ask me now, do I need a real estate license in Wisconsin to wholesale? I say, maybe. And I would probably think about that. And the answer is probably yes. And the reason why is when they put 710 out there, the disclosure part of the statute, they revised the regulation of licensees, agents, and brokers. And they put some pretty big penalties in there for doing the unlicensed practice of real estate. And those penalties used to be a couple $100, and so nobody paid attention to it. Now the penalty for the unlicensed practice of real estate in Wisconsin is $5,000 and 6 months in jail, or both. So they really indicated, I think, to us that they are going to take this more seriously. But this law, this 452, has been on the books since I've been a lawyer. It's just always been there. And nobody ever did anything about it. You maybe had one or two people who got nicked with it because they did something else. But I can't think of a single case where I know of a person who got fined under that section. They just didn't do it. So I think now that they're saying this is a big penalty, And it's not just, oh, I've had some wholesalers say, well, they don't regulate me, so they can't impose that fine on me. And it is very clear in there that if you have more transactions than they allow under statute, they definitely can fine you. And the rule on that is so weird that, honestly, I keep looking it up and going, wait, what does it say again? So I'm going to read it. It says, if you have a pattern of sales or exchanges, 5 sales in 1 year or 10 sales in 5 years, you have to have a license. It's a presumption of a pattern of activity. So like, it doesn't say your LLC, or it says you, and whether you own it or not. So if you are just buying stuff for your personal use, technically under this statute, you should have a real estate license. So I always tell people, look, this came all together. So we should take a hint that since it all came together and these penalties are not a joke anymore, that they are telling us that they intend to enforce it. It's a great taxation method for them. And $5,000 each time you do it, I think that's what they're saying.
So what's interesting is this even would go beyond wholesaling. It would go to fix and flipping.
Yes.
And presumably on a fix and flip, you have the buy side and the sell side, and that would be 2 transactions.
2, right. That would be 2 transactions.
So, you're talking at maximum, you could basically, do 2 fix and flips and buy a fix and flip per year, and you're within, regulation. But outside of that, you need to start thinking about obtaining a real estate broker's license.
I think that you do. And in Wisconsin, a salesperson is under a broker. So some states are very different. Some states it's just called a broker, and your experience level determines your level. But we have a salesperson, and that person is supervised by a broker. So it's more than just, I'll just get my license and forget about it. It's not that easy. You have to be supervised by somebody. And that's where it starts to get kind of troublesome, because if you have to be supervised by somebody, now all your transactions have to be supervised by somebody. And now you have to pay them to supervise your transactions. So of course, flippers and wholesalers are like, I'm not doing that. I don't want them knowing anything about what I'm doing, or I don't want to pay them for the privilege of me doing deals. And so it starts to kind of snowball where we get into this much bigger issue that people do not want to deal with. And so they see regulations like South Carolina or Illinois, where wholesaling is in the statute. Right. There's going to be a lot of resistance from people because they don't mention specifically wholesaling in the licensing statute. And all we really got was this like disclosure. We sort of, every other state is going, no. And Wisconsin said, just disclose. Right. So I'm interested to see what really happens here, because, and I hate to say we have to kind of wait, but unfortunately, until somebody gets hammered with this, we're not going to know how to advise them. And so I am telling people, hey, look, this is what happened. This is what the penalty is. I think you're operating at your own risk if you don't at least consider that you need a license. And so that's how I'm advising people.
It feels a little bit like the wholesale part of this law is like a sideshow.
It is.
I mean, as you're breaking this down, the fact that they would regulate how many transactions I could just as an individual do over the course of a year, or how many that would be before I have to be licensed. Right. And if I'm doing it just for myself, that seems like the bigger regulation on this whole thing.
But that regulation has been in effect forever.
Okay.
Forever. It's not, that is completely unchanged. The only part of that statute that changed was the penalties. And so if it was just, before it was a couple $100, it just wasn't significant. Right. And so nobody cared about it. They're like, well, if they start fining me, so what? I'll just pay it. I don't care. $5,000 or potentially a jail term, like that is no joke to mess around with. Can you imagine having to budget $5,000 a transaction because that's how they're going to tax you now? To me, that's horrifying. That was way worse than just this disclosure statute. So, I mean, you could tell your clients very easily, if you're in Wisconsin, don't forget the disclosure. Or here, I drafted you a contract. Here's your disclosure. Don't worry about it. The other part is way, way worse, I think. And they kind of just snuck it under the radar. And I think that's a little diabolical personally, because at least in these other states, they're like, no, you can't wholesale. We're not going to let you, or we're going to regulate you pretty significantly, and we're going to do it. This, they just increased the penalties and kind of went, so what do you tell people? Yeah, I think that penalty is very scary. And I think it's an intention to enforce it. Why else would you increase the penalty over 10% and include some jail time? That's crazy to me.
So in Arizona, we have very similar disclosure regulations when it comes to wholesaling. But we also have licensing statutes that very clearly say if you're acting on your own behalf in a real estate transaction, that you don't have to be licensed. And it's clear that that's an exception from the licensing laws. However, we do know that the individuals that were behind the disclosure regulations, the wholesale disclosure regulations, or the lobby group behind it, was the realtors.
Yes.
They were clearly like down at the Capitol testifying and pushing it through. And once again, like you said, all it did was, okay, you have to disclose, but it really wasn't anything like we saw or are seeing in South Carolina or Pennsylvania.
Right.
It was like, okay, much ado about nothing. Were the realtors behind the Wisconsin law? Do you know?
I think they were, but I don't think that it was very well organized. And we, like I said, we have this dichotomy between the control of the legislature here. It's very strongly pro-business. And so I think this was very much, a collaborative compromise that kind of came out of, and if you look, I looked at the statute and I kind of looked at the legislative background, and you can kind of see they were way more focused on landlord-tenant law. There was a lot of landlord-tenant law going on at the same time and changes that they wanted. And so I think this became one of the things that kind of got sacrificed because they were way more concerned about some other things in real estate than they really were about wholesaling. And I think you can see it in the end production. They just kind of, well, okay, you want something in there. All right, we'll put this in there and we'll give you this. Let's get back to the real work, which in the same term of real estate, it was all about landlord tenant law. And they were really fighting hard on some of those provisions. So it's almost like this got kicked out as a complete compromise to get some other things done. And I'm not saying they won't come back in light of South Carolina and Pennsylvania and Illinois. And maybe this was just the first shot over the bow for wholesalers in Wisconsin. But it doesn't have a lot of teeth in it. And it's pretty easy to meet the requirements of the disclosure. And I think if it drives people out of Wisconsin that aren't disclosing to sellers and are really trying hard to pull the wool over sellers' eyes, then great. It did what we wanted it to do.
Right.
But I'm just not sure it really did a whole lot. And I think we have to see how are they going to enforce the regulation on licensing for real estate people, like, non-licensees that may violate this statute now. I'm more interested in watching that. Although I think there's going to be a lot of litigation from people trying to rescind things under this statute because disclosures weren't made.
Right.
Yeah. And I just think because a lot of people don't know about it. I think I mentioned before, I was at AREA last Thursday night, and more than half of the people there did not know that this had come out. They did not know anything about it. And there was a lot of like, oh, what do we have to do? What do we have to do? And I'm like, I've been talking about this for months now. Like, guys, come on. But they just don't, it just wasn't enough to make the news to really get people excited. When you look at South Carolina or Pennsylvania's new law or Illinois, Ohio, some of these other states that really went after wholesalers, it just didn't do it.
Right. Yeah.
So,
well, and for example, the South Carolina law, the way they defined wholesaling was very broad. Basically, if you market a property that you only have an equitable interest in, you're wholesaling. And it doesn't matter how what disposition method you're using.
Right.
As I read Wisconsin, if I understand correctly, it seems as though if you plan to double escrow, you don't have to put the disclosure in. Is that accurate?
Well, the problem is that Wisconsin statute talks about intent. And so
Okay.
I think that's where you violate it with a double close. And so if I was doing a strict analysis of that statute and trying to tell a client, hey, let's just disclose, even if you're going to double close, because really your intent there is to pass it to a third party. You're not planning to keep it. And most of the times you're using the third party's funds to close on your first transaction. And that's not really intent to close on it. And so I think that they're going to focus on this intent a lot more, because if you read that statute, they are very clear that it is all about intent and what you intend to do. And so from my perspective, intent is, I would define it as this: do you have the money to close on that property yourself if you had to? And so if your intent is, I don't have the money to buy this property outright at the time I wrote this contract, then your intent is to wholesale it. And it's very easy to prove.
Right.
Give me your bank accounts at the time on February 1st, 2025, when you intend to close on this thing after the fact. And if you can't do it, then you did not have the intent to close, and you should have given the disclosure. So I think people think as wholesaling as like a intro to real estate, and you don't need a lot of money and you don't have to have the money to close on it. And all of those things are true, not true. Like, I don't want to get into all of that. But if we're focusing on your intent and what you did, I would rather disclose and not worry about it than not disclose and get caught down the road. Now you're arguing, like, how long you want to have this argument and pay one of us to defend you to try and get this process move. I mean, it's astronomical what it would cost. And it's just simple, disclose.
Right.
So,
Well, and I'm with you. I mean, that's the thing, right? It's like, oh, well, can you not disclose here? Can you not disclose there? It's like, why not disclose? Why not just be straight up with the seller and be like, hey, I'm not going to be the in person on this thing, whether that's assignment, double escrow, et cetera. One of the things, and it's a little different transaction method, but I am curious your thoughts on it. Is we had an attorney from South Carolina on, and he was explaining he has this program called the installment method.
I heard about that.
Yeah. And so he's doing like short-term land contracts. And then you either assign the land contract or you end up with an end buyer. Basically, it's like a purchase contract, but with a recorded interest in the real estate. Would you recommend the disclosure being in that document as well?
Well, I'm gonna go back to the statute, and in Wisconsin, the purchase agreement says any kind of transaction. It doesn't say, well, these are accepted and not for land contracts, and basically an installment contract is basically a fancy way of saying land contract in Wisconsin, which is a recorded interest in a property where you kind of go on. So I would say you're splitting hairs at that point. You have a purchase agreement with the seller. I wouldn't want to argue that your installment sale to buy the property that's in a document that says you're going to buy the property. I would not want to be the one who's arguing that's not a purchase agreement in front of the court. I think that's a losing argument from the very beginning. And I mean, yes, I'm taking a really hard line with this and people don't like it. I understand. But when it comes down to litigating something, I do not want to be the lawyer that has to stand up and make the argument that that installment sale is not a purchase agreement because you didn't really intend to buy it. That's a losing argument in my mind. Like, the judge is going to laugh at us. And I don't like judges to laugh at me unless I'm cracking a joke or something, or saying something silly about someone who's testifying. Okay, yes. But I don't want to set my clients up for a losing argument down the road. And so I'm not criticizing him because I am not familiar with the South Carolina law. And maybe he's got some way that he's working through it. And I'm not bashing him in any way. I'm just saying, here in Wisconsin, I don't want to be the person that has to make that argument that that's not a purchase agreement, because I think the statute's pretty clear. They're trying to be as inclusive as possible about what a purchase is. And I think that's going to be a hard argument to make, that you didn't intend to buy the property. You just sort of had this agreement to do something in the future, which is really buy the property. So I don't like that argument, but again, that's me. And I am telling clients, look, disclose. If you're going to ask me, should I? The answer is disclose. So don't call me. If you're asking, should I? The answer is yes, you should.
Right.
So if I missed this, I apologize. But the intent, what you intend to do, is that a necessary or an actual part of the definition of the wholesale transaction? You had to have had the intent. And where I'm going with this, to make this question even longer, is
That's okay.
what do you do with the person who didn't intend to wholesale at the commencement of the transaction? Had the funds, was prepared to do one thing, and then intent changed as the transaction changed, and they decided that they wanted to wholesale. At that point, can you cure the issue by doing a subsequent disclosure, or sorry, you needed to do this at the institution, at the initiation of the transaction?
Yeah, the statute says no later than entering into the purchase agreement as a buyer. So if that is when you started, I would just disclose. So when people come to me and they say, I don't know if I'm going to wholesale or not. Well, is it a possibility that you might, or have you in the past? Because if I can at all call you a real estate wholesaler, and in my mind, did you ever do a wholesale deal? You're a real estate wholesaler in Wisconsin now. So you have an obligation to disclose. So I would say, if it's possible at all that you're going to change your mind and maybe wholesale this, which happens all the time. Somebody offered me a great amount of money for me to just wholesale it to them. So I said, hell with it. I'm not going to flip it.
Yeah.
Right. That happens all the time to people. And it's, to a certain degree, I think you can determine that, especially now, the way the market had been going, that's a possibility. And if that's a possibility, you need to disclose. And so somebody said to me, well, I wholesale sometimes, but most of the time I'm buying now, I'm just going to flip. Well, you're a wholesaler because you have wholesaled, and we can produce evidence that shows you've wholesaled, because by your own estimation, you've wholesaled. So if you ever have, and you might in the future, you need to disclose. It's so simple to disclose in this state. It's just so simple. There's just no excuse for not disclosing. It's a sentence in the offer now.
Yeah, basically, if you want the option, that language has to go into your standard form contract at this point.
I think it does. And it's not hard. We don't want to make this complicated. Just quote it right from the statute. It's not hard to find the statute. It's not hard to quote it. We're happy to help you, draft a whole bunch of different disclosures that we think you should have in there. So when I was wholesaling prior to this law, I used to say right in there, hey, I don't know what I'm going to do with this. I might keep it. I might wholesale it. I might rent it out. I might do a lot of different things. I don't know. So just in case, I just want you to know, I don't know what I'm going to do with it. And is that enough now? No, I think you have to refer to the statute now. But I never had a problem with those disclosures with sellers. I just read it to them and said, I don't know what I'm going to do. Are you okay with that? They didn't care. They loved that I was telling them that some of this might go on, and they were always informed. And I think we have a duty to do that as wholesalers, regardless of where you are. I think you have that duty. Wisconsin says you do now. So,
So in Arizona, basically sticking with the theme of disclose, when our disclosure rule or law came out, I worked with a lot of clients to revise their purchase contracts, or at least, add a sentence into their purchase contracts, very similar to Wisconsin, that, buyer's a real estate wholesaler, blah, 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 blah.
right.
And one of the things I did, just because, the idea of it just being buried in the fine print, I actually was like, no, you know what? We're going to disclose it. We're going to make sure that the seller even, fully understands what's going on. And I added an initial block below there, and I actually have the seller would you recommend that, even in Wisconsin?
I absolutely would. I always have sellers initial stuff that's changing the standard language of a standard contract. So if they're using in Wisconsin, we have a contract. It's a WB11. It's the contract that realtors use. It's from the Realtors Association. It's just a general contract that everybody uses. There's very easy to do an amendment to that and have the seller, hey, I'm disclosing to you that I'm a wholesaler. You understand what that means. Sign here and initial sign something that shows that you gave them that disclosure and that they saw it and they understand it. I think that's a critical part of any disclosure, whether you're in Arizona or you're now in Wisconsin. We want them to see it. We want them to acknowledge that they saw it. You can't just bury it in a bunch of language and say, oh,
Right.
but I did it. Well, they didn't see it.
Right.
So you don't want to fight. You don't want to fight rescission. That is not something you want to fight, because you're going to tie that property up forever. The seller's going to have all sorts of damages that potentially they could recover from you if they can rightfully show they could rescind it. It's not something that you want to get involved with. That's not a fight that you want to have ever. And it's avoidable.
Right. Yeah. I mean, and that's the thing. I've never had anybody come back to me and say, oh, that language we added, I'm having problems with it because sellers aren't, agreeing to it and it's scaring them away. They just initial it and they move on, and I think
part of the deal.
Yeah, it's just part of it. And it's so easy and so simple to just have in your standard form. Even if, like Andy said, you don't intend to wholesale or you have the money to close on it and something changes. Well, if you have the disclosure, you don't even have to worry about it. It should just be, if you're an investor, it should just be part of your contract in all contracts, whether it be a purchase contract, a land contract, et cetera, it should just be in there and have the seller initial that language.
Right. I don't think it's worth having the argument about something so simple. And we really got away with it in Wisconsin compared to some of these other states. And so I would say disclose, it's easy, and then kind of watch out for the future to see what comes down the road with this regulatory stuff and whether or not you need to be a realtor or not. I think it's coming. So
Well, let's switch from the seller to now the third party assignee. And so they didn't just say, okay, well, hey, the consumer seller, you need to disclose or give them this language and let them know what you're doing. Now it's like, well, so the front end of the transaction, but now the back end of the transaction, there's disclosure.
Right.
So what do you have to disclose to the assignee, and why is that disclosure of importance or value to that assignee?
Well, you have to do the same thing that you did with the seller. You have to tell the buyer that you're a wholesaler. That's it. I mean, and they also have the right to rescind if you do not disclose that to them, that you're wholesaling them the property, because they might think that you are the seller at some point, and that you need to give them the notice that this is going on, primarily because title gets messed up. Different sellers agreements get messed up. They have the right to know that you're wholesaling and that there could be these kinds of problems that come in at the last minute. And that also a lot of times you're using their funds to close the first part of the transaction. And, there's arguments about whether or not that's, legal or legitimate or should be done. But, here it is still largely done, and they have the right to know that. And so disclosing to them, if you fail to do that, they also can rescind the contract up to the date of closing. So they can back out at any time too if you don't do this disclosure for them. So I think all in all, your standard forms should have disclosures to the seller, disclosures to the buyer. You avoid the rescission and all those problems, and then you're good to go.
Now, you mentioned they can rescind up to closing.
Right.
So let's say that, you mentioned you were at a RIA the other night and everyone's like, what, and obviously if they're saying what
They've all
now,
closed.
they've all closed without this language.
They have, right?
They've been closing for weeks.
They've been closing for months without this stuff in there, because the statute said it was effective as of the day it went out for any contracts that were executed after March when it came out. So technically, anybody who entered
Right.
into any transactions, let's just say April 1st forward, because it came out at
Yeah.
the end of March. So
Right.
April 1st forward, all of those have closed now. It's August.
Right.
So all
Yeah.
of those have closed now. So
What's the
that-
result? I mean, are they in trouble? I mean, is there anything that the parties
No.
can do to,
No, the statute says that once it's closed, that right of rescission ends. And so at least there's this, the seller can't come back now and say, oh, you didn't tell me, so I want my property back. I'm going to sell it for more. So it's kind of like, yes, the damage is done, but the right of rescission ends with the closing. And that's consistent with Wisconsin law, honestly, because you don't have 3 days, right of rescission after we close in Wisconsin.
Mhm.
So you have some rescission rights with loans, but we typically don't close until those rescission rights have passed here. So it's consistent with Wisconsin law is once you've closed, the contract is done. Now, that doesn't mean that you wouldn't have damages to the seller, for fraud or misrepresentation or that kind of stuff. We're just saying your contract itself has closed, and so there isn't that right of rescission anymore.
Right. So the seller's remedies under the statute, the
Right.
assignee's remedies under the statute are done, no more,
Right.
and they have no claims under that particular statute if the transaction actually closes.
Or the buyer. Both of them are
Yes.
both of them are closed out. So if you gave disclosure to the seller, but you forgot to do it to the buyer and it closed, no harm, no foul, no more rescission rights for either one of them at that point.
Hey, Amy, I know that you had mentioned earlier this only applies to residential properties.
Right.
How broadly does Wisconsin law define residential property?
Well, in the statute, they say 1 to 4 dwellings, and then they refer to this other statute. They say pursuant to this 10161, and that describes it as 1 or 2 family properties. So what I'm telling people is they were inconsistent here. They didn't draft that very well. And so I would just do 1 to 4 because the statute itself says it applies to 1 to 4 residential units. And so I would say it doesn't apply to land because they specifically said dwelling. So I think you can wholesale land without it if that's something that you do. And then commercial stuff. Commercial defined by everyone is anything above 4 units, or an office building or a market or a strip mall or like that kind of stuff. You wouldn't have to put the disclosure in there.
So all the way up to a fourplex.
All the way up to a fourplex.
Wow.
I know it's confusing. They really messed up that statute because they said 1 to 4 as described in this statute, and that statute says 1 to 2. So you're like, well, which is it? I'm
Right.
going to go with what they said in the statute, which was 1 to 4.
Yeah. But there is no harm in the disclosure.
No.
So even if you're buying land, multifamily, commercial, and you're
No
going to
harm.
wholesale it, no harm in just keeping that language in there. And plus that way, if the seller ever comes back and is like, hey, you didn't disclose stuff to me that would have been material. You didn't let me know that you weren't going to be the buyer.
Right.
You still have the disclosure in there, and it's a statutory disclosure that complies with Wisconsin law. I mean,
I would, but
Yeah.
there's some people that really want to stay close to what the statute says and they don't want to be burdened
Right.
in other areas. I agree with you 100%. I would put them in every contract, mostly because I don't want to forget. So
yeah.
if, especially in the circumstance where you have the seller is selling you multiple things. They're selling you a single family house. They're selling you a couple duplexes, and maybe they're selling you a 6-family. That happens a lot to our clients where they're buying multiple types of property from a seller that just, wants to get out there, having financial trouble, or they just want to be done with it. That happens where all of a sudden, hey, you bought that from me. Will you buy something else? Or will you buy this? Or will you buy a package? Or will you buy these 3 together? I would be afraid I would miss it on one of the contracts or part of the contract. So I'm just advising my clients, put it in everything and worry about it later.
Right. Makes sense.
So I think that's a good practice point. I think it's something wholesalers should really consider.
Well, Amy, this has been really good information. We really appreciate you taking the time to be with us. Tell our listeners how they can find and connect with you.
Sure. You can go to amyfarrow.com. That is a way where you can get any of the real estate information. You can connect with me if you have a question. I work for Russell Law Offices now, so if you have a legal question, you can reach me there. But any way you want to do it, Facebook, LinkedIn, I respond to all of them, but your best bet is amyfarrow.com.
All right, and we've put those links in the description of our YouTube video. Amy Farrow, thanks so much for being with us. We appreciate it. Let's do it
Thank you.
again soon.
I'd love to. Thanks, guys.
All right,
Thanks, Amy.
with that, everybody, that is our show. Thanks so much for joining us. Make sure to join us today at 2 p.m. for The Collective, and we'll see you next week.
Have a good day, everyone.